May it please the court, I appear for the appellant in this matter, instructed by Mills and Co. solicitors, and my friend Priscilla Balgobin-Boyro appears for the respondent, together with my friends Nilan Venkatasmy, Kushla Jagiwan, and Yudish Lachminaraidu.
We're grateful to have assistance with how those names are pronounced. Thank you.
I did my best. Milady, before I start with the submissions, I would need to make some preliminary remarks. First of all, regarding the bundle of authorities, which is quite bulky, and we are aware of this, and we would like to explain that this is due to the nature of this case. The judgment of the Court of Civil Appeal has questioned a fundamental principle of the Mauritian civil law. And we had to produce French academic authorities, French case law, and then, of course, local cases interpreting the French authorities, which explains that the bundle of authorities is quite bulky.
Well, compared with some of the cases that we get elsewhere in this building, it's not bulky at all. The only problem is that some of it is in French, and we will have to see what we can make of that.
Yes. I was going to address this issue.
Let's just get on with it and see how we go.
All right. So I would just like to say that during my submissions, I will endeavor to translate the excerpts of the authorities I'm going to refer to.
Well, both of you have provided those excerpts that you have in your written cases. You have both provided helpful translations.
Yes. Some excerpts are not translated. I'm going to give an oral translation during my submissions.
Well, I'm sure that will be helpful. I suspect that most of us have sufficient French to understand, but we wouldn't guarantee it. Some of my colleagues do, but...
In case you need me to translate, I'll try to do so, my lady. But in case the court requires translation for specific authorities, we, of course, propose to cause the said authorities to be translated and to be provided to the court after the hearing. Now, regarding the appellant's case, I would like to refer the court to the grounds of appeal, which are at page MS 290.
Sorry, which MS number, please?
290.
290, thank you.
And this to explain how the appellant's case deal with the different grounds of appeal.
I think my record of appeal goes up to 280. If you're reading grounds of appeal from the notice of appeal, then I've got it loose. But obviously my colleagues have got it at 290.
I'm reading the grounds of appeal from the notice of appeal.
Yes, well, I've got that. Thank you very much.
But in fact, what we're interested in is not the grounds of appeal.
Yes.
We're interested in the statement of facts and issues.
Yes.
And the issues, as they are in that document, are what we're interested in.
Yes, so, my lady, this is a rather simple case. You will see from the plaint, I'm going to refer your lordships to the plaint. The plaint is at page 7 of the hard copy of the brief, of the record.
The amended one is at 57, I think.
Yes. And you will see, my lady, that this is a case where there is an agreement between Sotramon Limited and the defendant for the defendant to, the defendant was entrusted with the carriage of goods from Mauritius to Felixstowe in the UK.
Yes.
And somehow the plaintiff avers that part of the cargo was not delivered at Felixstowe, and this is the basis of their claim. And they are claiming from Medicine Shipping, the appellant, the sums which are set out in the plaint. And the problem in this matter, as it is stated in the statement of facts and issues, the issue in this matter.
Well, the problem is whether they can sue in tort rather than in contract, isn't it? That's the problem.
Yes, that's it. That's the problem.
What difference does it make?
It makes a big difference, my lady, because if the action is grounded in tort, then the plaintiff would be able to avoid the clauses of the contract. And in fact, this was the intention of the plaintiff in this matter. You would know that the plaint was amended by the plaintiff after we raised a plea in limine as to the jurisdiction of the court, inasmuch as there was in the bill of lading a clause attributing jurisdiction to an English court.
That's no longer an issue in the case, is it?
It's no longer an issue.
Yeah, well,
The issue now is that at a certain stage, we understood that the intention of the plaintiff was to ground their case in tort. And this is not possible under Mauritian law as we understand it, because it violates the very fundamental principle of the non-concurrence of contractual liability and tort. And therefore, a plea in limine was raised to that effect. And the trial judge decided that the respondent could not proceed with the case because they had wrongly grounded their case in tort, whereas there was a contract. Those are the issues which would have to be decided.
So what is your position about the relevance of faute lourde in a contractual claim? See, because what they're alleging is faute lourde, isn't it?
Yes.
And they're only alleging that as the basis of a tortious claim. What is the impact of faute lourde on a contractual claim?
This issue is addressed, my lady, in the second part of our case, and what we are submitting is that a faute lourde would not be an exception to the principle of non-concurrence.
No, I'm not asking you that.
Yes.
Supposing that this were a contractual claim, which you say it should be,
Yes.
what would faute lourde's effect supposing it could be established, we haven't seen any pleadings which suggest what it would be yet, but supposing it could be established, what would the effect of such a fault be on the exclusion and limitation clauses in the Bill of Lading?
Yes, the answer is very clear, inasmuch as it is given by Article 1150 of the Civil Code, the Mauritian Civil Code and the French Civil Code. And the Article 1150 provides that a debtor is liable only for damages which were foreseen or which could have been foreseen at the time of the contract, where it is not through his own intentional breach that the obligation is not fulfilled. That is, in case there is a folklore, we remain governed by the contractual regime, but then, according to Article 1150, what would happen is that the plaintiff would not be limited to the foreseeable damages, because there is a footnote. That is, clauses limiting the liability would not be applicable.
So clauses limiting the liability would not be...
Or
excluding, would not be applicable. Yes. So, why does it matter whether it's in contract or tort? If folklore is a way of getting round the contractual exclusion clauses,
yes,
whether the claim is brought in contract or in tort, why are we here?
Because the law has limited the effect of the footnote. The only effect produced by the footnote is to affect the validity of the clause limiting or excluding liability, but not the time bar clause, not the jurisdiction clause.
Sorry, not the what?
The time bar clause,
right,
or the jurisdiction clause.
But do they matter in this case?
They matter in this case.
Well, the jurisdiction point is not before us. Does the time bar matter?
Yes, it matters. It mattered because there is a short time limit in such cases, and in fact, even under tort, this case is now time barred, and although the respondent was non-suited, they cannot enter the case anymore because the case is time barred under contract or tort.
Now. In other words, if they had to start again, it would be too late, you're saying?
It would be too late, and this is why they are here today.
Yes, but it doesn't answer the question that you were asked, I don't think.
Yes.
That tells you why you can't start, why they can't start again. But as at the time when the action was begun, and the judge had to deal with it, why did it matter whether it was put in contract or tort if faute lourde was alleged?
The reason why it is important, my lord, is regarding the set of rules which is going to govern the case.
All of that, which such as?
And in this case, as we have explained in our case, the facts of grounding the case in tort would allow the respondent to avoid the application of the Code de Commerce, which has reproduced the Hague Visby rules, the Hague rules of 1924, because Mauritius is not a signatory to the Visby rules, which came later. So this is a fundamental issue for the industry, because there is this international convention, which, according to us, ensures an equilibrium between the parties, between the obligations and the safeguards between the parties. And the fact for the respondent to lodging a case in tort would allow them to avoid the application of the specific regime which applies to carriage by sea. This is one of the issues in this case. And
you also say that they switched their case to tort to overcome the problem about jurisdiction.
yes,
And that if, therefore, they can't, as you say they can't, sue in tort, and they would have to claim in contract, they couldn't do so in Mauritius.
they must do so in Mauritius. They must sue in contract. They can't sue in tort.
No, but they can't sue in Mauritius in contract because there's exclusive jurisdiction in the English High Court.
Yes, but
That point has been decided.
But it was, it was decided in the sense that faced with the problem, they switched their ground of claim. If they went back to their original ground of claim, they'd be reconfronted with the original problem, wouldn't they?
the reasons given by the trial judge for overruling our objection as to jurisdiction did not really, was not based on the fact that it was an action tort and not in contract.
No.
Other reasons are given by
Positively held that the same, that the ruling was the same whether it was contract or tort, page 112.
Yes,
Page 112 in the hard copy.
exactly.
That's what she
Therefore,
said, isn't it?
Therefore, at a certain stage, we were no more concerned with the issue of jurisdiction because there was a decision.
All right. So if we put jurisdiction to one side,
Yes.
your case is that the problem with the classification of the case, according whether it's contract or tort, is that if it's tort, the Code de Commerce doesn't apply,
Yes.
and hence the Hague regime for carriage by sea doesn't apply. Is that it?
That's it. And
Now, where in this case, why does that make a difference?
well, it makes a big difference because the liability of the carrier
Yes.
under the Code de Commerce
Yes.
would not be the same than under.
Do you mean it's limited in amount?
It is limited in amount, and what is important, and we have produced authorities to that effect, under the regime of the Brussels Convention of 1924, a party alleging faute lourde would not be able to avoid the clause limiting liability. It is only a dull, which is an intentional fault, which would allow a party to avoid the clauses limiting liability.
Mr. Arni, I wonder whether we can make this even more specific if we look at the conditions of contract of carriage on page 171 in the record.
Yes. Rather hard to read it.
It's quite hard to read, but some of us have struggled.
Yes.
And in the right-hand column, about not quite halfway up, there's a paragraph beginning, neither the carrier nor the ship shall in any event. Have you got that? Well, it's about 9 paragraphs up from the bottom of the right-hand column.
Part of paragraph 21.
It's under paragraph 21, third paragraph of paragraph 21. And so far as I could see, that is the limitation of liability to £100 sterling unless certain conditions were fulfilled. And it seems to be agreed that the conditions weren't fulfilled. Is this case all about the fact that if the matter proceeds in contract, you say that they are limited by that clause. Whereas if the case proceeds in tort, you say that, you concede that they are not limited by that £100 limitation clause.
We would have to concede that. There are authorities to that effect, and this is the reason why the Hague Rules of 1924 were amended by the Visby Rules, yes. And this is Article 4 bis, which I have produced. And I would like, if you give me one moment, I would like to quote an authority which I have produced and which is extremely important, my lords.
But I'm not clear of your answer to Lord Wolson's question. What is it that you concede?
I concede that in case the action is grounded in tort, that the respondent would effectively be able to avoid the Code de commerce. Because, and I referred to the Code de commerce regarding carriage by air.
But you're being asked about this particular limitation clause, which is in the contract rather than in the Code de commerce. It may, for all I know, reflect something that's in the Code de commerce, but you're being asked, would this £100 limitation apply in tort?
Well,
I think the answer is no, it wouldn't. Okay.
Not in tort.
Right.
And this was the problem.
But also, forgive me,
yes.
Would this £100 limitation apply in contract if faute lourde were established?
No.
It wouldn't, would it?
No, it wouldn't.
So it doesn't make any difference. Unless there's something in the Code de commerce which would make a difference.
But in tort, purely in tort, if you exclude the contract and the regime of the Code de commerce,
yeah.
Then the shipper would be liable in case of faute lourde, and the clause limiting liability would not apply. And I would really like to
Sorry, can I just get clear before you move on? Does your answer, Lord Hughes, amount to this, that if the claim were in contract, then to get around the £100 limitation, faute lourde would have to be established, but if the action is in tort, that condition, that limitation doesn't apply at all anyway, faute lourde or no faute lourde?
I'm sorry, my lord, could you please repeat the question?
I think you said that if the action was framed in contract, the claimant could get over the £100 limitation if he established faute lourde.
No.
Ah.
You did say that.
You did say that.
And indeed, paragraph 54 of your case says the same, doesn't it? 52, I'm sorry.
We may be at cross purposes. Shall we try it again?
52, my lord?
Yeah. Hong Kong Shanghai Bank. It says, and perhaps I've misread it, I may very easily have misread it, Stan, but I'm looking at the sentence which begins 4 or 5 lines down. The Court of Civil Appeal in Hong Kong and Shanghai Bank rightly held that the effect of faute lourde is that the exclusion clause of liability would be of no avail.
Yes.
Yeah.
But
That's why I asked you what I asked you right at the beginning.
But I have explained that, and I have authorities to that effect. Let me quote the authority.
Well, no, just before we do that.
What's the proposition before we look at the authorities?
Right. The proposition, my lord, is that the specific regime which is applicable in this case and which would be applicable if the claimant does not avoid the regime by grounding an action in tort, the applicable regime would not allow a party to exclude the clause limiting liability only on the ground of faute lourde.
You say that's the effect of the Code de Commerce?
Yes, my
Got
lord.
it.
Yes.
So it would not allow, I didn't catch, the applicable regime would not allow the carrier wouldn't allow the claimant to overcome the limitation.
No, he would have to establish a dole,
You would have to
which
establish
is not,
dole,
which
yes.
is not a serious fault, but an intentional.
Intentional fault, dole, yeah.
Yes, you did say that earlier. We were just trying to make sure
Right. So
quite what you were saying.
two possibilities. One is the claim is in contract, the other claim is in tort. We're all now clear, I think you're saying, that if a claim is brought in contract to overcome the limitation clause, dole would have to be established.
Yes,
Right.
it has not been pleaded.
Right. Now, if the claim is brought in tort, does faute lourde have to be established in order to overcome the limitation?
There is no
Or
No.
no,
There is no limitation.
There's
there's no limitation. So if
The contract doesn't apply.
So the benefit of being able to go in tort is that the claimant can be untroubled by the limitation clause, whatever the degree of fault.
That he's only alleging faute lourde. He's not alleging ordinary negligence.
He is alleging faute lourde
Yes, he is.
But he doesn't need
as an exception to go in tort.
Yes.
That's all.
Yes.
But then this is in fact the issue for the industry. Although in my submissions I address the effects on the contract law in general, but as far as carriage by sea is concerned, this would be the effect of this judgment, allowing shippers to avoid the regime applicable under the Code de Commerce, which is a reproduction of the Convention of Brussels of 1924, simply by averring faute lourde.
And does the same apply to carriage by air?
No. And this is the difference. The Warsaw Convention
Yes.
has an internal device within it to the effect that even if a party grounds his action in tort, the limitation provided by law would apply.
Yeah.
The problem is that this is not the case for the Code de Commerce governing carriage by sea. And the reason why it is so is because Mauritius is not a signatory of the Visby rules. The purpose, one of the purposes of the Visby rules was precisely to avoid this problem of actions grounded in tort. There is an Article 4 bis, which I have produced, which specifically says, even if you enter an action in tort, the limitations provided by law would be applicable. And in fact, in the case of Arjuk, Aerostral against Arjuk, which I have communicated to the court, which is a case of carriage by air, the learned judge comes to the conclusion that the plaintiff has entered an action in tort, but even if they do so, this would have no effect.
Yes.
Because there is an internal device within the law, which is not the case here.
So perhaps the solution to your problem is to persuade the government of Mauritius to accede to the Hague Visby rules.
This is a very long shot, my lady. This is a very long, and what do we do in the meantime? This is a major problem. And in fact, I have produced authorities where you would see the travaux préparatoires to the Visby rules, where the Italian representatives says exactly that. That is, in Italy, at a certain stage, although Italy is a civil law country, at a certain stage, the Supreme Court in Italy permitted parties to enter actions in tort. And this is one of the reasons why Italy was one of the supporters of the amendment brought by the Visby rules, to the effect that even if you enter an action in tort, you would be limited by the clauses provided in the contract.
Is it common ground that if an action in tort is available at all, it's only available if faute lourde is established? In other words, is faute lourde an essential ingredient for there to be a tort?
No, not at all.
No.
As you understand it, what is the tort which is alleged against you? I mean, we should have to ask the plaintiffs this, but in the meantime, it might help if you told us what you think it is. What is the tort that is alleged against you?
Yes. The tort in Mauritius is based on Article 1382 of the Civil Code.
Of the French Civil Code.
Of the Mauritian Civil Code.
Sorry, Mauritian.
It's an exact reproduction of the French Civil Code.
Yeah.
To the effect that any act of any person which causes a prejudice to another person would entitle the other person to damages. That's it. And there are 4 articles only under the regime of tort in the Code Civil, whereas there are 250 articles under the regime of contract. And you can see what the respondent is trying to avoid, the 250 articles of the contractual regime.
All right.
Well, I'm getting thoroughly confused, but I think are you saying that it does matter whether the claim is brought in tort or in contract because there's a lower threshold to succeed in tort?
Certainly.
Well, it's a much wider proposition, isn't it?
Certainly.
It's a much wider proposition.
Yes. Certainly.
Yeah.
So in fact, at the moment, the only tort claim that's pleaded is a faute lourde claim,
Yes.
without particulars.
Not at all.
No.
Not at all. It's only a faute lourde.
But faute lourde, as I understand it, sorry, don't make no assumptions. In the law of Mauritius, is faute lourde a separate, identifiable form of tort, or is it simply an aggravation of any of the torts that are in the 4 articles?
It is an aggravation,
It's an aggravation.
Of liability in the contractual regime.
It's an aggravation of liability in the contractual regime, yes.
Because you are no
What's its relevance to tort, if any?
We have to keep in mind this Article 1150, which is extremely important, and which says that when you have a contract, you would be liable only to pay foreseeable damages.
Yes, got that.
If there is a faute lourde, this doesn't apply anymore.
Yep.
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 Then you have to compensate fully the victim.
But in tort, does it make any difference whether I allege faute lourde or not?
There would be no difference, except in damages, possibly, where the court would consider that it is a fault which is extremely serious. It might have an effect, but not in law.
Might increase the damages.
Not in law.
Well,
But it
If the court increases it, that's in law.
would increase the damages in case of faute lourde.
but anyway, it's not an independent tort, is what you're saying.
Yes.
Yeah. Right.
What's your best case for saying that in Mauritian law, basically, if it's a contractual claim, it's got to be brought under the articles dealing with contract, and you can't avoid those articles by bringing it in tort?
There are legal reasons and practical reasons.
Well, I think we understand the practical reasons. That's really what we've been talking about.
I would like to expatiate a little bit on that,
Yeah.
because I know that my friend's submission is to the effect that by admitting exceptions to the rule of non-cumul, you are giving a chance to victims. But in fact, in practical terms, and this is very important, and this concerns the management of the case. In the case of La Patinoire, which we have provided, there is a plaint under a lease agreement. But the plaint is grounded in tort, although there is clearly pleaded a breach of the lease agreement.
Yeah.
But the claimant avers footload in order to avoid the contract. And the judge listening at the plea in limine decides that he would have to hear evidence to decide whether there is footload or not.
Yeah.
And he proceeds to hear evidence. The problem is under which regime? This is a major problem, because if you have not
What
yet...
do you mean?
I see what you mean.
Because if there is a footload, then it is tort.
If footload is an exception
Exactly.
to the exclusivity of the contractual regime, then the judge is going to have to decide whether there's footload before deciding whether
Taking the case.
the case can be decided in tort,
Yes,
in which case, of course, footload is not the point.
exactly.
Which is what happened in La Patinoire, isn't it? The one about the skating
It
rink.
happened in La Patinoire,
Yeah.
and the judge... Let me give you one example.
Well, the judge
One example.
the judge there said that, he rejected the plea in limine and went on to try the issue of whether there was footload or not, although he held that there wasn't.
Yes.
Is that it?
Yes.
Yeah.
And the problem is, during the proceedings, what were the rules governing the proceedings? One example, Article 1341 of the Civil Code provides that for any contract which exceeds 5,000 rupees, oral evidence is not admissible. You need a written contract. This is Article 1341. If you have not yet decided under which regime the proceedings are going to be conducted, what do you decide as to the contract? Can you prove the contract by oral evidence, or would you request a written agreement? This is a major problem. This is why in France, the issue of which regime is going to govern the proceedings is decided at the very outset, not after you have heard the trial. Because we are in a sort of no man's land. The judge is hearing evidence, but in a sort of no man's land. We don't know which regime is governing the trial. This is a major problem. The second problem is as follows.
Is which?
The second
sorry.
practical problem.
Yeah.
And we can take the case of La Patinoire. What happened in La Patinoire is that when the judge, as you stated, my lord, when the judge decided that there was no footload, then the case was dismissed. The judge decided to dismiss the case.
Yeah.
Whereas, if we apply the principle, the well-established principles of our civil law, a party having footload would only have the benefit, if he establishes footload, would only have the benefit that the damages would not be limited to foreseeable damages. But at the end of the day, we would know under which regime the proceedings are heard. And secondly, in case the footload is not established, the plaintiff would nevertheless have the benefit of damages.
He'd have his ordinary contractual claim. Yes.
Which is what the judge said at the very end of La Patinoire, having decided that there wasn't a footload,
So
non-suited the plaintiff in tort, and left hanging in the air the question of whether there was any contractual liability.
In terms of administration of justice,
Yes,
this is a terrible waste of time. This is a terrible waste. It doesn't work. It doesn't work. And this is why we should be careful in Mauritius before departing from French law. Because we are a small country, we don't have a lot of universities and researchers. Because this sort of interpretation, creative interpretation of the law, leads to situations which are quite absurd. This is a major problem with this theory of the exception of footload, which is not at all supported by French authorities, of course.
So, your case, is it that the Court of Appeal was wrong in this case and equally wrong in Cascadel?
Yes, but in Cascadel, the situation is different.
Oh, all right. Come to it then.
Okay.
Well, we've asked you a lot of questions. We better let you get on with your submissions.
Right.
But you'll see what we're interested in.
I've noted that the first part of my case was not touched by your lordships, and rightly so. I would submit, because the first part of the appellant case is to the effect that the court was wrong to decide that in Mauritius there might be a principle of non-cumul of contractual and tort, but there is no, it has not been extended to a principle of non-option, which means that a party cannot ask for damages in both tort and contract. But the real question is, once there is a contract and a breach of contract, whether he can still choose. And what the Court of Civil Appeal says is that it's not very clear in Mauritius, whereas our case is that it is extremely clear. And this has been confirmed in the case of Hong Kong Shanghai Bank, where the court clearly says where you are having a breach of contract which has caused prejudice, you can't choose. Non-option. You can't choose. You have to go in contract. And I do not propose to insist on this part of the appellant case because my friend for the respondent seems to have accepted, we are in agreement. I would refer the court to paragraph 36 of her submissions.
Yes, that's what I thought. I thought you were agreed on that.
Yes, where my friend for the respondent clearly says the principle of non-option has been consistently applied by the Mauritian Supreme Court. And therefore, clearly, my friend does not support the judgment, which says exactly the contrary. And I would refer your lordships to the judgment of the Court of Civil Appeal. This is page 264 of the report. There are conflicting authorities. This is the starting point of the reasoning of the court. There are conflicting authorities as to whether the principe du non-cumul should be extended to amount to a principe de non-option. So the statement of the respondent cannot be reconciled, I would submit, with this statement of the court. And I would also refer the court to page 260. Yeah. At line 35, where the court says However, there are equally authorities which tend to show that we should not follow the tendency of some French authorities to extend the principe de non-cumul to a principe de non-option. Paragraph 36 of the respondent's submission clearly cannot be reconciled with the finding of the court. So I propose not to insist on that. Otherwise, my case...
So the real dispute is whether there's a fault-lord exception.
Yes, this is the where we do not agree. And this is part 2 of my submissions. And I would like to remind the court, therefore, that fault-lord is treated under our law by Article 1150 of the Civil Code, and there is no reason why we should not apply Article 1150, which provides for a specific sanction in case there is a fault-lord. Article 1150 is to the effect that where there is a fault-lord, then the damages are no more limited to foreseeable damages. That's it.
Where have we got Article 1150, Mr. Oni?
It is at page 10 of my case, my lord.
Have we got it in the bundle of authorities?
I would refer your lordship to tab 50.
Thank you.
Tab 50. Which is Encyclopédie Dalloz, Verbo Responsabilité.
This is Dalloz, is it?
Yes.
Thank you very much.
And this is at page MS 805, page 376 of the hard copy.
376.
376. And I would like to translate paragraph 167.
167, yes.
167. So this is my translation. Compensation of unforeseen damage in case of dull or fault-lord. Article 1150 of the Civil Code requires the author of a damage to compensate the victim for unforeseen damages if the said author has committed an intentional fault that is dull in the performance of the contract. The gravity of the fault committed by the author of the damage deprives him from the favor granted to those who have committed a fault in good faith. However, the fact, and this is the important part, however, the fact that the contractual fault amounts to a dull does not entail a liability in tort. Yeah. The only consequence of the intentional fault is to aggravate the liability, which remains contractual. Yeah. Although Article 1150 mentions only the dull, the case law applies the Latin adage, culpa lata dolo, equiparatur, and makes the fault-lord produce
Equivalent.
I think it's page 376, paragraph 167.
I couldn't follow the...
Are we on page 376, paragraph 167?
We're on paragraph 167.
Yes. 167. Follow the translation.
Oh, it is, it's...
Yeah.
Translation looks okay to me. Sounds okay to me.
So you were on the sentence which begins Bianca le texte ne parle que du dol.
Yeah.
La jurisprudence applique l'adage culpa lata dolo equiparata. Yes, we're familiar with that.
The same effect.
The same effect.
Yep.
The footload, which, contrary to the dol, is not intentional, nevertheless shows serious carelessness on the part of its author. So,
But your point is that Dallos says the only effect is to aggravate the damages, it's not to turn it into a delictual claim.
Yeah.
to aggravate the damages within the
contract.
contractual regime.
Yes,
Yeah.
yes. Yes. We've understood that.
So this is the basis, essentially, for not accepting the exception of footload. And this basis is a legal basis, and no reason has been given by the respondent as to why
Have
should
we-
not apply Section 1150.
Have we actually got the text of Article 1150?
Yes. It's at page 10.
We've got it in your case.
It's in my case.
Yes.
Page 10, MS 377.
Paragraph 38 of your case.
Yes.
Got a 10.
Sorry, which MS number, please?
MS 377.
377.
For your case?
Yes.
Yeah. Yeah.
You're only liable for damage that you foresaw or ought to have foreseen, but not if there's dole.
And footload is assimilated.
Is equivalent, equiparated.
Yes.
Got it.
And I also have authorities to the effect that the Cour de Cassation has consistently decided that where the breach of contract amount to dole or footload, then the action should be grounded in contract. And I have quoted authorities at paragraph 43 of my case, which is Cassation première, 28 novembre 1967, Cassation troisième, 13 November 1970. And I have also at paragraph 47 of my case, I have other authorities which are quoted in Encyclopédie Dalloz, Responsabilité contractuelle, tab 51. Tab 51. And I'm referring to paragraph 40, MS 808. Which deals specifically with inexécution civilement qualifiée. Inexécution civilement qualifiée, meaning a non-performance which is civilly characterized, and this means footload and dole. And the author here says, and I'm going to translate this my lord. So it's 51. So this is what the author says. Civilly characterized non-performance. Reinsertion in the contractual sphere. A third exception has disappeared. And when the author refers to a third exception, she is referring to a traditional exception which concerns the doctrine and not the case law. She is saying that it has disappeared. It is no more decided that the civilly characterized non-performance, that is dole and footload, constitutes a tort, a faute délictuelle, which escapes the contractual liability. Yeah. And I have communicated two authorities, Civil 3e, 13 November 1970, which is tab 28, and Civil 1e, 30 May 1978, which is tab 68. Those judgments are quite clear. Tab number 28. MS 679.
Which is the passage we need to look at.
The passage, which is important, if we don't look at the facts of the case, you would see the second paragraph, starting with mais attendu.
Sorry, oh yes.
Mais attendu que, and it has to be read in French before I translate it. Mais attendu que, si lourde soit la faute reprochée, si lourde soit la faute reprochée par le maître de X ou ses ayants droit à l'architecte relative à un manquement aux obligations contractuelles, l'action en garantie est éteinte après l'expiration du délai de 10 ans. And the time limit of 10 years is provided under Article 1792 of the Civil Code, which governs contracts between an architect and a client. And the issue in this case was whether by grounding an action in tort, the client would escape the time bar of 10 years. And what the Cour de Cassation says is, si lourde que soit la faute, however serious the fault might be, nevertheless, we are still in contract, and therefore the 10 years time bar would apply. Very clear authority. And I would also refer to tab 20.
Could you just help me about what follows the reference to the 10 years at the top of the second page of this report? Celle qui est intentée en application des règles. What does that passage mean?
The court goes further to say that not only the footload would only entail an action in contract, but then the court says that the only way to escape the contract is in case there is a fault which is extraneous to the contract.
Yeah.
And where there is a non-performance, of course, it is not extraneous. And in our case, which is before the court, the fault is not extraneous to the contract. It is an obligation under the contract which was allegedly not performed. And therefore, si lourde que soit la faute, it is contractual liability. And the second judgment at page 29, the second judgment at page 29 is to the same effect. This is the column on the left, my lord. You will see the second paragraph.
Yeah.
The same wording, si lourde que soit la faute reprochée par le maître de l'ouvrage à l'architecte relative à un manquement de ses obligations. It is exactly the same wording. Yeah. So this is a consistent case law, and I would also refer your lordships to.
And that also excludes only the case where it's based on a faute extérieure au contrat.
Yeah. That's the earlier one, isn't it? The 67. Yeah.
So the third authority is at tab 68.
Now, is this in the supplementary
The
bundle?
second bundle,
Yeah.
the volume 2 of the Joint Authorities bundle.
Exactly the same.
In this case, my lord, the Cour de Cassation quashed a judgment of a Court of Appeal and held, however lourde, si lourde que soit la faute, reproach to an electrician.
Where do we find this, please?
This
987, I think.
987.
Yeah. 1, 2, 3.
and
Fifth
five,
paragraph.
I think it's 543,
It is.
tab 68. This is a decision of 1978, where again the same reasons are given by the court using the same formulation.
Is this the paragraph starting attendu, cependant,
Yeah.
si lourd, etc.?
Yes.
Yeah.
Now, this isn't an architect's liability case. This is about an electrician who made some sort of installation on a farm and some cattle got electrocuted, yes?
Yes.
So what was the reason why it mattered in this case? Was it also time bar, or was it something else?
It is a case where
There's a ref-
it is a matter of time bar. Court of Appeal. I'm sorry. It's not a matter of time bar.
It's not.
In fact, no. It's a matter of insurance. Insurance. The electrician was insured only for tort, for liability in tort.
Of course.
And what the court says is that the insurance doesn't have to guarantee the insured, because it is not a liability in tort. Mm-hmm. He's an electrician, he has performed works, and the works were defective, therefore it is not a liability in tort, and therefore the insurance company would not have to guarantee the insured.
Thank you.
Can you just translate the words at the top of the second page under analysis? It's that sentence starting dès lors manque de base légale au regard de l'article 2270.
This is tab 69, my lord.
Yeah. 68. No, 68.
Yet,
It's just at the end, under analysis, that sentence, dès lors manque de base légale, ending up with the words à sa charge un faute extérieur contrat qui le liait. I'm not sure what liait means.
Isn't that a different case?
Is that another? I thought it was analysis of the same case.
Same one. It's a comment, isn't it?
Yeah.
Comment.
Is it?
Yeah.
It could be a comment, but it's...
You tell us. Is it a commentary on the same case, or is it talking about a different case?
are we talking about tab 68?
Yes.
Top of page 544 in the hard copy.
So it's the case of Laurent Électricien.
We think so.
But it looks as if it is a commentary on the case that immediately precedes it, to which you have referred us.
Delo, yes. Yes, it is a commentary. It is a summary of the decision, my
But
lord.
what does it say? Manque de base légale, in the absence of a legal basis, and then what's the rest?
In view of Article 2270, the judgment which applied the 30 years time bar regarding an action against the victim, of the victim against the insurer.
Against the insurer. Yeah.
Against the insurer.
Okay.
So here are four
Just
cases.
carry on. It says the 30-year time bar. Continue, please.
It contains a quasi-delictual responsibility for the entrepreneur
Without sans relève,
without having established a fault extraneous to the contract.
Yeah.
This is what the court says repeatedly. If it is a breach of contract which has caused a prejudice, then it is contractual. If the only way to ground an action is in tort is that the fault should be extraneous to the contract.
Yeah, well, in fact, that repeats the text of the judgment itself.
Yes, it is a commentary. It is
1, 2, 3, 4, 5 paragraphs down, attendu cependant que si l'eau qui était.
yeah.
So here are the authorities which demonstrate that there is a consistent case law in France to the effect that the faute lourde is certainly not an opportunity for a claimant to enter an action in tort. And what is important here is that all the local case law purport to apply French authorities. At no time, the local authorities, which have been communicated, seem to say that the situation is different in Mauritius, so we are going to depart from French authorities. At no time this is said. This is part of the submissions of my friend, but as far as the authorities which have been communicated are concerned, whether l'inattendu, Fidèle, La Patinoire, all those authorities purport to be relying on French authorities. The problem is that there is a misreading of the French authorities. And this has been shown in the different cases you will see in the appellant's case at page 14 for the case of l'inattendu, 15 for the case of La Patinoire, and the case of l'inattendu is quite extraordinary. And if I have a few minutes, I would like to deal very quickly with this case, unless your lordships have already, has already taken cognizance of this decision, because this decision is the starting point of the subsequent case law, which consider faute lourde as an exception to the rule of non-cumul. So very quickly, I would like to deal with this case in particular. I don't think I will have the time to deal with the case of La Patinoire.
Which case do you want to refer us to, please?
The case of l'inattendu, my lord.
L'inattendu, tab 16.
Go Express.
Yes.
So what about the T-shirts?
Yes.
Yep.
Precisely.
Which divider are we?
Tab 16.
60.
16, yes.
And which page are we? Electronically.
It is MS 590, my lady.
Thank you very much.
So in this case, and it is very important to note that the judgment of l'inattendu was delivered on the 10th January 2001, whereas the plaint in the present matter was lodged 3 months before, that is in October 2000. And the case of l'inattendu changed everything. The facts in l'inattendu are as follows. The plaintiff, l'inattendu, entrusted goods to the defendant, a freight forwarder, for the said goods to be sent by container to Réunion Island. The parties entered into an agreement embodied in a negotiable combined transport bill of lading. However, the container in which the goods were sent was not unloaded in Réunion Island due to the fact the said container was not marked on the day plan for disembarkation. As a result, the container went to South Africa and the goods reached Réunion Island after a considerable delay. The plaintiff claimed damages. Firstly, a claim representing the claim made by the consignee in reunion. And secondly, the plaintiff asks for damages for prejudice he has allegedly suffered. The bill of lading contains several clauses protecting the freight forwarder, including 1, a clause which excluded the liability of the freight forwarder in case of delay. 2, a time bar clause to the effect that any suit against the defendants should be brought within 9 months. The defendant sought to rely on the time bar clause as the action was entered more than 10 months after the goods were delivered. Being fully aware that the defendant would rely on the terms of the contract, the plaintiff company decided not to ground its action in contract, but in tort. The plaintiff averred that the defendant's failure to disembark constituted a footload. The court recognizes the principle of non-option and quotes as authority the arrêt of the Cour de Cassation to the effect that Articles 13.822 and subsequent find no application where a fault is committed in the performance of an obligation. So even l'inattendu acknowledges the existence in Mauritius of the principle of non-option. However, the court, founding itself on a textbook of a French author, Boris Stark, states that the said author, I quote, opened the door to a case for a tortious liability in a contract when there has been footload. This is the exception. And this type of interpretation of the authorities explains why there are problems regarding the application of French case law.
So what you say about the Stark paragraphs 1758 and 1759, which the judge quoted on 165.
Yes, so this, and I would refer to the respondent's case.
What you say about Stark 1758 and 9. Wrong?
No, Stark is right, but he is misinterpreted by the court. And
well, what Stark says, if I've got it right, is that in the event of faute lourde, the defaulting defendant isn't entitled to the benefit of the clauses in the contract which would otherwise protect him.
Let me.
That's what it says, yes.
Yes, let me bring you to the authority of Stark.
But it doesn't say anything about delictual liability.
No. But the judge does.
This is tab 60. Tab 60.
Yes, that's where we are.
Yeah,
Tab 60.
that's Stark itself.
889. Tab 60 is Stark. It's
895.
889.
Thank you very much.
Ah. Well, it does, doesn't it? Because if you look at hard copy 457, about 903, 904, paragraph 1757.
You can refer to page 895, the electronic page 895, where I have reproduced are the paragraphs referred to by the court in the case of l'inattendu. You will see that in l'inattendu, which is therefore tab 17,
yes. 16.
In l'inattendu, and this is MS page 594 and hard copy page 165. Mm-hmm. This is extremely important. The author at paragraph 1758 says, and I'm going to rely on the translation provided by the respondent's case at page 18 of the respondent's case. This author only says, according to some authors, this is at page 18 of the respondent's case. According to some authors and some case law, the option should, however, be allowed in the presence of a default due to dole of the debtor or a particularly serious breach. In such a case, the debtor would not deserve the preferential treatment offered by the contract, in particular as regards the amount of the indemnity and, in certain cases, the limitation period for a legal action. In such cases, the contractor escapes from the contract and deserves no more respect than a mere third party. Then, at 1759, you will see that there are dots in the judgment. If I may refer your lordships to page 594, 165, hard copy. 1759 starts with dots. Mm-hmm. And there is something missing here. What is missing is, and now I refer to the textbook of Mr. Starr. Sur le plan des principes régissant le problème du cumul, cette décision est critiquable. And this is precisely the part which is missing. and the judgment, if you look at the judgment, and in fact, if you look at the respondent's case, much emphasis is given to this author, as if he was supporting the exception in case of faute lourde, whereas he says that this is critiquable. This is open to criticism, but this is the part missing from the reproduction of this text in the judgment. And I must say, unfortunately, it is also missing in the respondent's case.
It is true, though, isn't it, if you look at the text of Stark, not as quoted in L'Inattendu, but in its original, in its unexpurgated, in the full form.
Yes.
Hard copy 45789.
889, I think.
895.
Yes.
The two paragraphs that we've been looking at and which the judge quoted, that's 1758 and 1759, follow on a heading, exceptional recourse to tortious liability, don't they?
Yes.
And what is he saying at 1757? Le recours à la responsabilité délictuelle est ouvert. Is he saying, or at least does he appear to be asserting, that you can invoke tortious liability in some cases, one of which is the presence of dole or faute lourde?
Yes. And he even quotes a judgment, but what I mean is that this amounts to an academic debate.
Yes.
And my submission is that the court in Mauritius cannot interpret French law by referring to the fringe. This is not French, this is an academic debate where the author says that according to some authors and according to some isolated judgments,
Yeah.
it has been said that there might be an exception. I would remind you the authority I've quoted earlier, which is Encyclopédie Dalloz, which is the latest authority we have of 2014, where it is said that this has disappeared. In case of faute qualifiée, that is inexécution civilement qualifiée, faute lourde dole, this exception has disappeared. Disappeared meaning even in the doctrine, in the French doctrine, this possibility of exception has disappeared. And I have quoted 4 judgments, very clear judgments, to the effect that this exception is not accepted. But the fact is that I would humbly submit that the way the text is written cannot be interpreted as a very firm and established authority. It is clear that the author is saying that there are debates on this issue. And in my submission, the court in Dinatran did not refer to the mainstream of the French case law, but to isolated judgments and isolated authors.
What's the date of the Stark? It's not clear from the title page. It's the 3rd edition.
Should have the edition. Unfortunately, I don't have the.
It doesn't seem to be there, but
No, but I would be in a position, of course, to inform the court after the hearing. But
you're rather hoping the date is before the date of the latest edition of Dalloz, yes.
Quite clearly. The Dalloz is 2014, updated 2016. So it is quite old authority, and it is not an authority. It is a discussion about the possibility evoked by certain authors and found in a few isolated judgments. So, and the change which has been brought in our law by such a decision cannot be based on such discussions. And this has brought havoc, and I'm going to demonstrate that to your lordships, because in this case, I have submitted that the judgment is flawed and totally incoherent. Why is it so? Now, the court held in l'inattendu that the plaintiff is entitled to go beyond the contract and ground his claim in tort. This is MS 595. This is the 3rd paragraph of the judgment, where it clearly says, in view of the above, that is the...
What's the internal page, please, Mr. Arne?
595, 166.
Thank you.
3rd paragraph, my lord. 3rd line. In view of the above, I find that the plaintiff is entitled to go beyond the contract and to ground his claim in tort. But then, and he also says, that neither the limitation of liability clause nor all the time bar clause in the contract would avail the defendant. So there is a total exclusion of the different clauses of the contract. But then, a few lines after that, the judge says that the plaintiff company should not be allowed to go beyond the contract. And
What did he say then?
169, about halfway down,
Oh, thank you.
after the quote.
Yes.
he should not be allowed or throw the contract overboard. So there is a blatant contradiction in the judgment. But this is not all. What the judge did is that, in fact, he applied the clause limiting liability, that is, clause 9.
Well, I wondered about that, but I rather thought perhaps what the judge was saying was that the plaintiff hadn't proved that it had suffered the loss, if you look at the end of the paragraph that you've just been taking us to.
Yes. But you can see the confusion.
In the absence of any acceptable evidence, I find the plaintiff hasn't proved that it actually paid out the money that it was claiming back.
The principle in tort is that damages should be fully compensated.
Yes.
Right. So there is no reason why the judgment would say, after having said that the contract would not apply, there is no reason why at the last page he says, I find that plaintiff's claim for damage if it suffered should be strictly limited to what is specified in clause 9.
Yeah, no, I appreciate that.
And not only that, he says, I further find that plaintiff did serve a mise en demeure within 9 months, and since it entered the case in court within 10 months, it should not be limited by the time bar clause.
Yeah.
Whereas he has said that time bar clause was not applicable. So why should he justify an action entered after the 9 months? Mm-hmm. So, and all the judgments where they tried to escape the well-established principles, the coherent principles of our civil code, and apply this theory of the exception of folklore, we end up with this type of judgment.
Now, the decision in L'Inattendu was considered, was it not, by the appellate court in Air Austral, which you referred to in your printed case. I don't think you've taken us to that in your oral argument.
Yes, I must say that in Air Austral, the court attempts to save l'inattendu by saying that what the judge in Air Austral understands from l'inattendu is that there was an extraneous
Precisely so,
fault.
which is the point you were making earlier. Because in Air Austral, the court does appear to grapple with the core questions of principle that you're referring to.
Yes, the court tries to reconcile l'inattendu and Hong Kong and Shanghai Bank. But unfortunately, in my submission, it is quite clear that the court in l'inattendu does not deal with an extraneous fault. The court in l'inattendu clearly says this is a fault which has been committed in the performance of the contract, but there is an exception, which is folklore. So the court in l'inattendu is not dealing with an extraneous fault. But of course, the statement of the learned judge in Air Austral is correct.
Well, that's what is perhaps rather more important, isn't it? Because that's a later decision of the appellate court.
Yes, my lord, and treat is that for the time being, there has been no decision stating expressly that l'inattendu was wrong in law. But this, in my submission, would be the effect of Hong Kong and Shanghai Bank.
Well, it's also the effect of Air Austral, isn't it? I appreciate it wasn't necessary in Air Austral because you had the Code de Commerce in any event. But they clearly say in Air Austral at 83 that the general view is that the action remains one of breach of contract.
And there is, in Air Austral, my lord, there is a veille éthérée, which is quoted, and this is tab 47. Tab 47. A very clear authority, and this would be at page MS 786 and 357 of the hard copy. And I will try to translate paragraph, therefore, my lord, paragraph B, starting with on a parfois proposé.
And this is from what? What is this?
This is from veille éthérée, les obligations. Sorry, terre similar in lequette. Les obligations, 10th edition, my lady. Page 885, paragraph B.
Yes.
It has sometimes been proposed to admit the cumul de responsabilité, the concurrence, in case of an intentional fault of a party to a contract. The view being expressed that the DOL should allow the application of rules applicable to tort. One can notice that the interest of the debate is limited in as much as, in case of a DOL has been committed, the specificity of the contractual regime diminishes because, as per Article 1150, the liability is no more limited to foreseeable damages.
The very point that we were taking up with you at the outset, yes.
Exactly. Supporters of concurrence, that is cumul, have claimed that the ordinary rules of contractual liability cannot apply in a case of intentional fault, DOL, such a fault giving rise to a liability in tort, responsabilité délictuelle. The reasoning is inexact. In case of non-performance due to an intentional fault, DOL, the rules pertaining to liability are admittedly different. But this is not due to the fact that the liability ceases to be contractual. How would the liability stop to be contractual when we are concerned with a breach of contract? The explanation is elsewhere. In case of intentional fault, by way of punishment, the legislator excludes the rules which alleviate the liability of the contractual debtor. The Cour de Cassation has indeed condemned concurrence of liabilities in case of DOL as well as in the case of faute. And the two judgments which are quoted have already been referred to. Civil 1er 28 novembre, tab 28, and Civil 3e 13 November 1970, tab 29.
Now that appears to be in line with what the Mauritian Court of Appeal said in the Air Austral case, that the base remains contractual, whether
It's a direct quote from it.
whether you've got a faute lourde or not.
Yes, the case of l'inattendu is based clearly on a wrong interpretation of Boristar. And there is also the case of La Patinoire, and the case of Fidel, and the case of Nestlé Products Mauritius Limited against Cascadel, which are based on a wrong interpretation of abus de droit.
Well, I think it says, for your purposes, the interpretation put on it in the later case is good enough, isn't it? You don't need to show that it was actually wrong. If the earlier case has been decided, has been interpreted as being applicable because there was some extraneous fault, not a fault founded on the contract, you may say, well, the reasoning is dodgy, but nevertheless, it's consistent with your argument. That is, there is that limitation.
Except that in the case of Sotramon, the case which is before your lordships, in this case, l'inattendu is interpreted by the Court of Civil Appeal as an authority to the effect that faute lourde is an exception. The interpretation is not the same as in Aerostral.
Right.
And they say the same in Cascadel, don't they?
And they say the same.
I appreciate Cascadel was based on abus de droit, but they say the same in Cascadel.
They say the same in Cascadel, whereas it is not necessary.
You say all those are wrong.
In Cascadel, they say the parties have entered an action in tort because there has been an abusive termination of a contract.
Yeah.
And because there is this exception of faute lourde, they can go in tort. But in fact, it's not necessary. In fact, it is well established that where there is an abuse of a right, it is not a non-performance.
Yeah.
Because what you are reproaching to the other party is that to have used his rights under the contract, not to have not performed his obligations, but to have used his rights under the contract in such a way which is prejudicial to the other party.
And is that tort or not?
This is tort.
That is tort.
That is tort. So there is no need to have recourse to an exception. Under French law, it is well established that in case of an abus de droit, the action is in tort. And I would refer your lordship to an authority I have produced to that effect. And here again, there is a misinterpretation of...
This had better be your last point, Mr. Ali, because you're already out of time. But on the other hand, we have been asking you a lot of questions. So.
And I would refer to Juris Classeur, droit à réparation, which is in the second bundle of authorities.
Tab 70, is it?
70.
Yeah. Yeah.
Which is 990.
Is it 990? I don't have the...
My lord has found it, so that's all right.
Yes, most probably.
Head of the game.
There it is.
So I would refer your lordships to paragraph 45. Mm-hmm. And this excerpt is quoted in the case of Cascadel, of Fidel, and the courts consistently misread this authority. I'm going to give you the translation. So, can the judge, of its own motion, I'm sorry.
No. Paragraph 45.
Yes.
No, I'm sorry, I don't have a translation for this one, unfortunately. So I'll read it in French, then I'll try to translate. Therefore, responsabilité née de l'exercice abusif ou fautif d'un droit d'origine contractuelle. L'exercice abusif par un contractant d'un droit d'origine contractuelle permet de mettre en œuvre la responsabilité de ce contractant. S'agissant de l'exercice d'un droit au surplus abusif et non de l'exécution du contrat. This authority says clearly, because this doesn't concern the non-performance of a contract, the result is that the responsibility would be in tort. And unfortunately, in the case of La Patinoire, of Fidel, they use this authority to say that abus de droit is an exception to the non-cumul. And the respondent as well submits that an abus de droit is an exception to the rule of non-cumul. Whereas the rule regarding an abus de droit is an application, a strict application of the rule of non-cumul, because we are not concerned with the non-performance of a contract. We are concerned in a case where someone is using his rights under the contract. And you will see that in the case of Cascadel, there is a finding from the judge to the effect that the parties were entitled to terminate the contract. Yeah. But because they have used this right to terminate the contract in an abusive manner, this would give rise to liability in tort. But this has been interpreted, unfortunately, in the case of Cascadel, as an exception, which it is not. And you will see that the Court of Civil Appeal in Nestlé against Cascadel has relied on the judgment which is before you today, that is the judgment of Sotramon. And what I would like to say is that in the case of Nestlé against Cascadel, the action was in tort because it was an abus de droit.
Because it was what?
Abus de droit.
Thank you.
An abuse of a right, but the court felt it necessary to justify the action in tort by saying that the abus de droit was an exception to the rule of non-cumul, whereas it was not necessary.
Well, Mr. Rani, I think you've made your argument very, very, very plain to us.
Thank you, my lady.
And if you'll forgive us, perhaps you could complete your submissions for the time being there, and we'll hear from the respondent,
I will.
And then you'll have a right of reply.
Of course. Thank you. Thank you, my lady.
Thank you very much. Thank you very much indeed. Yes, Ms. Balgobin Boyrou. Thank you.
Yes, my lords. In the light of the submissions of my friend just now, and in light of a written case that has already been submitted to the board, I propose to be quite to the point, but if there are any questions, then I would be very pleased to answer them. I understand that the main gist, Counsel for Appellant in a gist has submitted that the rule of non-cumul should not encompass the rule of non-option. Reference has been made to our written case, whereby we have explained as well that the rule of non-cumul, even in Mauritius, is quite prevalent. So my submission today is certainly not that in Mauritius, cumul is allowed as a matter of practice. So we are clear on the rule of non-cumul. With regards to the rule of non-option, which is the rule that basically allows parties that are bound by a contract to go beyond the contract and to sue in tort when there is fault law is an option that is available in Mauritius. Reference was made earlier as well to our written case where we had submitted that as a general rule, non-option was observed as well, but your lordships will see from our statement, from our written case, that a number of exceptions have been listed by us. So our stand today is that while generally there is no option, if a case is on contract, it should proceed on contract and not on tort. There are exceptions, and our judges have realized and applied these exceptions to permit a party to go beyond the contract. Many cases have been referred to already, and I do not propose to go into on the facts of the cases, but maybe only in order to enlighten the board, if I may just refer chronologically, very briefly to each case in order to convey to the board the gist of the reasoning of the judge. And it will be my humble submission in the end that the judges, that the various decisions all go in the same direction, but really there hasn't been so much controversy with regards to this subject. If I could start with the case of Kinuk Ramtali, 1977 case, it's at tab 15 of the brief, MS page 587. On the second page, my lords. Third paragraph. I would like to draw your lordship's attention to the fact that the Mauritian court already in 1977 seemed quite alive to the fact that the position in France was not similar to the one in Mauritius. I'm reading a few lines down the page. I'm reading about the 12th line down the page. Well, if I may read the whole paragraph. Now, it is quite clear that the plaintiff cannot have recourse to cumul.
I'm sorry, which page are you reading?
I am on page 159, tab 15, MS page 587.
Actually, no, the MS pages are one page out.
So it would be
So it's 588.
588. Third paragraph, milady. Now, it is quite clear that the plaintiff cannot have recourse to cumul in such a way as to recover damages both under the contract and in respect of the tort. For in that case, he would be indemnified twice for the prejudice he has suffered. We do agree with this proposition. It is also beyond dispute that he cannot proceed by means of a hybrid action in which he would ask the court to apply in turn the rules governing actions in contract and the rules governing actions in tort, according to what set of rules best served his purpose. For instance, he cannot invoke the contract so as to cast on the defendant the onus of proving that he was exonerated from his obligation by force majeure, and then ask the court to apply the rules of tort so as to recover unforeseeable damages. The above principles clearly apply both in Mauritius and in France. But some French go further and state that when damage is caused by a breach of contract, the victim must proceed under the contract and cannot base his action on Article 1382. We prefer to leave this highly controversial question for future consideration, as it is not essential to decide it in the present case. We merely note at this stage that the French procedure does not necessarily apply in Mauritius, that any examination of a problem would be incomplete without taking into account the effect of relevant local enactments, notably Rule 31 of the Supreme Court rules. As far as the first question is concerned, the action is clearly based on tort and no question of cumul arises. This is precisely in a gist the submission of the respondent today before this board. The case that has widely been debated this morning, the case of l'inattendu, is a case of 2001, tab 16. It is a one-judge case, and a case that has not gone on appeal, and that indeed has been referred to many times by the Supreme Court of Mauritius. Earlier, it was a submission of my friend that in the case of l'inattendu, parties have been allowed to proceed beyond the contract because there was a fault extraneous to the contract. I beg to disagree.
I don't think that was the appellant's case. The appellant's case was that a subsequent case, the Air Austral case, had explained, I prefer to call it Cargo Express, explained that one away by saying it was an extraneous cause. But as I understood Mr. Arney, he was saying, no, it wasn't actually an extraneous cause, and that was just a way of trying to explain away
Thank you, lady.
The decision in unattendu.
And we have the same reading of Cargo Express.
Yes.
And it will be my submission that the judgment of l'inattendu is a judgment where the learned judge has thoroughly thought, established, and laid down all the principles of contract and tort, and having done so, having quoted the relevant parts of Boris Stark, but we have just, that counsel for the appellant has just taken us through, has consciously decided to allow parties to go on the basis of footload. If I may take your lordships through the judgment, we are at tab 16, MS page 590. What is interesting in this case, my lords, is that the Code de commerce, which reproduces the French version of the Brussels Convention, apply in this case as well. It is a contract of transport. In this particular case, plaintiff have averred that there was negligence on the part of defendant and or its agent in disembarking goods, and we treat such negligence or imprudence as amounting to footload. Now, the plaintiff's case was that it had the right to exercise an option between the two regimes and had already done so. May I draw the board's attention to the fact that we have already done so as well. There is no cumul here. It is very clear from the evidence on record, from the briefs before your lordships, that we have elected to proceed on tort. If I may just briefly state as well, there was a brief discussion in the beginning as to the confusion which could result from a court proceeding with a case, not knowing if it was in the regime of contract or in the regime of tort. Here, in this particular case, we know we are in the regime of tort. If at the end of the day, after hearing evidence, the court comes to the conclusion that there were not enough elements to justify a footload, then so be it. But was a choice of the litigant. A clear choice has been made to proceed on tort. The litigant is, of course, aware that he could have gone under Article 1150 maybe, but he could have proceeded otherwise. But it was a choice based on the evidence of the case to proceed on the basis of footload. If I may go back to the case of l'inattendu, the cases quoted by his lordships, notably the case of Enough Mauritius Steam Navigation, and the Articles 1382, I do not propose to go through these again because we have just been through it, tend to show very clearly that the learned judge is aware and very alive to the fact that if there is a breach of contract, one should not automatically and cannot invoke Article 1382. But, of course, the learned judge goes on to say, while quoting the paragraph from Boris Stark, paragraph 1758 and 1759, that a choice can be made. And that in case, I will just translate it in English.
Where are you looking at now?
I'm looking at MS page 1594.
Yep.
Internal page?
165.
Yes, I see. So what are you going to translate? Because we've got your translations. In your case, haven't we,
yes,
this Balgobin-Boy rule?
Yes, there is a translation of 1758 and 1759.
Yes.
So it will be my submission that the learned judge, having read the parts from Boris Stark and unfortunately missed the last lines, which is an unfortunate state of affairs, I do concede, has taken the view that the tendency of judges to punish more severely blameworthy acts, breaches which are really characterized, inexcusable or inadmissible. There is nothing to prevent this aggravation of sanctions from taking place. I'm reading 1758 and 1759, my lord.
Yes.
1758, according to some authors and some case law, the option should, however, be allowed in the presence of a default due to dole of a debtor or particularly serious breach. In such a case, the debtor would not deserve a preferential treatment offered by such contract, in particular as regards amount of indemnity and limitation. So it is my humble submission, my lords, that the learned judge was very alive to that part of the article of Mr. Stark and these minority, maybe we call them maybe, decisions, and chose to apply those to Mauritius.
Well, now, in that case, the issue before the judge was whether a certain claim for damages should be allowed. Does the judge deal with the question whether the claim is being classified by him as a claim in contract or a claim in delict? I don't see that in the judgment. I may have missed it. It seems to me he's rather more concerned with simply whether the grave fault enables the damages to be claimed, whether it remains within the framework of contract or not.
But on the next page, my lord,
Yes.
second paragraph, after referring to the case of Ramjurawan and Mercantile Bank and quoting Henry Lalou, the judge states that the just quoted case described how the action in contract merges with the action in tort. In view of the above, I find that plaintiff is entitled to go beyond the contract and to grant his claim in tort. But I accept that the tort arises out of the non-performance of the normal obligations contained in the contract. This is in accordance with the extract from Bury Stark, 1758.
I'm not sure that I entirely understand that, the concept of merger, when there's a good deal of authority that they're separate bases of jurisdiction, they're one or the other. It may be that there's an option to go for one or the other. But the concept, has anybody developed this idea that elsewhere, that there's a merger of the two types of cause of action into sort of a polyglot cause of action?
I believe by using the term merging, my lord, what the learned judge has been trying to impart is, and which is basically derived from the article of Bury Stark, is that once the law has been proved, then one of the parties cannot avail himself of the benefits of the contract. And this is where the regime moves from a contractual.
So it's, as it were, overtaken by tort once you have faute lourde.
Yes. And while there is an existing contract.
If, Ms. Balgobin-Boyrul, if the position is that if you sue in contract but allege faute lourde, and if establishing faute lourde you are not bound by the limitation of damages, does it matter to you whether your faute lourde allegation is to be described as a contractual claim or a tortious claim?
In some circumstances it might not, but in some it might, my lord. In the case of tort, one of the parties will not be able to avail himself of all the conditions in the contract. So in some circumstances, he might very well be.
What about this case?
In this particular case, there is a limitation as to time, and there is no suggestion that we are out of time, but we have been time out.
Right.
In context, the case already entered. There is a limitation as to liability. If the claimant is allowed to proceed on faute lourde based on tort, then of course the amount of damages that he will be able to obtain from this contract would be much higher than one that he could obtain under contract.
Would it? Why would it be?
Well, because then there would be no contract, there would be no limitation.
But if the limitation, but if, as we have already, I think, established, if you establish faute lourde, the contractual limitation doesn't apply to a contractual claim, why does it matter to you that it's a tort claim rather than a contractual claim?
Article 1150 mentions dole.
Article 1150.
Yes. We can understand that there might be other things, like a time limit or whatever, and there might be the possibility of liability for simple negligence, not just gross negligence. But in terms of the amount of damages that you could get, I thought that we had it clearly explained to us that the contractual claim is not subject to the contractual limitation of damages if you establish faute lourde.
If there is only intentional breach, that would mean dole. But there are various theories that do state that dole can be assimilated, faute lourde can be assimilated to dole.
We've seen quite a lot of authority to that effect, haven't we?
At the end of the day, if the case, should the case proceed on tort in this particular case, then damages would not be limited. But here we have claimed moral damages. In this particular case, damages that have been claimed, of course, are not as per the bill of lading. More damages have been claimed when are foreseeable.
Yes.
And in this particular case, including moral damages, then all this would be covered under the tortious regime.
Well, yes, but Article 1150 clearly relates to contractual claims, doesn't it?
It does.
That's the one which says that ordinarily you're limited to damages which were foreseeable at the time of the contract, but in the case of dole or faute lourde, you're not. Is that right?
Yes, indeed.
Okay. Now, supposing that you ground your claim in tort, does it make any difference to the damages, or indeed to anything else, whether you are alleging faute lourde or something less?
Well, in this particular case, if under 1150 our claims which are not foreseeable are entertained and which there is no reason to state why we should not, including our moral damages, then no.
Yeah, but 1150 is about contract. I'm asking about tort. Supposing because you want to make your claim in tort, and you've said so all along. Well, not all along,
yes,
but most of the time. You've pinned you've said this is tort. Now, what I'm after is this: if it's tort, are the damages affected by whether it's faute lourde or not?
Well, at the end of the day, my lord, it is hard for me to answer this question in a straightforward manner. What I would maybe like to refer to, Article 1150 mentions dole, yes. And in the case of dole allows you to go beyond the contract and to claim. In this particular case, we have only had faute lourde.
Yes.
Provided we proceed under tort, under faute lourde, and that we are permitted to go under the tortious regime, but in my humble submission, we would certainly then be able to get all the damages that we have asked for here.
Yes, without the limitation. That I understand completely, but that would be the case in contract as well, wouldn't it?
Probably, yes, my lord.
All right.
Yes.
Could I ask another question while I've taken you away from what you were going through? Do you agree with what we were told by Mr. Arni about the way tort is defined in Mauritian law? Has he got that right?
Yes. Well,
really, anything which causes damage to somebody else?
Yes, indeed. But in quite a few cases that have been quoted today and that are before your lordships, there was a simple averment of faute. In those cases, under 1382, in those cases, one cannot be allowed to traverse outside the contract. So, which is why there is an important distinction to be made between a simple faute and a faute lourde.
Oh, that in contract, I understand that. But in tort, Does folklore mean anything at all?
Well, no, it's just folklore. Having been here, we have gone on folklore in order to be able to enable the claimant to go beyond the contract.
In other words, it opens the gateway for you, but it doesn't do anything once the gateway is open.
Yeah.
Yes, my lord. Yes.
Okay.
Indeed.
Yes.
Right. Thank you very much.
Yes.
So the main issue for us, as we'd already established, is whether folklore does open the gate.
Yeah.
Yes, yes, my lady. And our submission is that, indeed, if there is folklore, then the gate is open. In the case of l'inattendu as well, my lords, if I may just bring you back to that case, true it is that after deciding that one may proceed on folklore, the learned judge then limits the damages. But what I would like to draw your lordship's attention is to the fact that in that case, after an analysis, it is found that there is not enough evidence to substantiate a bigger claim. Even in the present case today.
Surely, even within the limitation, you'd have to prove your loss.
Yes, my lord. Yes, my lord. But
So why is the judge talking about the limitation at all?
Yes, I do concede that once the contract is set aside, there is no need to talk about the limitation.
If you're not talking about contracts, you're talking about tort. It's just a question of what loss you've proved, isn't it?
Just a question of quantum.
So why is he saying on page 170, the plaintiff's claim for damage it suffered should be strictly limited to what is specified in Clause 9?
Yes, my lord. The wording might have been worded differently.
Okay.
You can see it. I believe that after analyzing the evidence, the learned judge did not find enough evidence to justify a greater claim.
I think it was a question of the claim not being sufficiently substantiated, but why choose that measure of damages as the...
Why did the plaintiff even get the Clause 9 amount if he hadn't proved it?
I believe it was a question of quantum.
Yes, it was.
Even in the case of La Patinoire, my lord, having decided that one could proceed on folklore, it all boils down on a question of evidence.
Right.
In this particular case, having decided that the respondent in this case could proceed on folklore, the trial court would of course have to go and analyze the evidence and thereafter see if folklore is justified and if there is any need to award damages as per what is being asked. I think that in my submission, the case of l'inattendu also shows that the learned judge bore in mind that damages were not to be given for the mere asking. We have heard earlier about the Code de Commerce and the Hague Rules, and the submission of the appellant is that if in Mauritius parties are allowed to go beyond the contract and claim in tort, then under the Code de Commerce that could result in a lot of uncertainties. We've seen that in the brief, we've seen that in this written case, but in my humble submission, this judgment shows that our courts are very much alive to the fact that damages are not to be granted just for the mere asking. Quite a few other cases have also been referred to by my learned friend, but in my humble submission, they can easily be distinguished here. The case of HSBC, which was a 2002 case, tab 14. In that case, it was a two-judges case, and the respondent's stand is that the judgment is correct. The plaint was only entered on food sample, Article 1382. And it is our submission as well that when there is a contract, one cannot proceed under tort. Under food sample. even in the case of TFP International, which was a 2002 case, tab 25, a two-judges case, same set of facts, my lords. No faute lourd was averred, but faute simple. There was mentioned again in that case that when there is a contract, one has to go in contract. And it is the stand of the respondent again that we do agree. We do agree with all these authorities, because if there is a contract, one should proceed in contract. But if there is a faute lourd, this is when we state that the door is open. The case of Fidel is a 2005 case, and it is a case of abus de droit. We do agree with appellant submissions. When there is an abus de droit, then it is a tortious case. If I may refer your lordships to the case of souvenir casting, tab 24, MS page 660. In this case as well, my lords, the case of l'inattendu was referred to. It was a case that was entered against the defendant, stating that the defendant was at fault, negligent, and or imprudent, and that the defendant company, and that the acts and doings of the defendant company constituted a faute lourd or a faute caractérisée. And in this case, learned counsel for plaintiffs confirmed that the case is one in tort, and the evidence was adduced to support the fact that there was faute lourd or faute caractérisée. I apologize. It was submitted on behalf of a defendant company that plaintiffs have only stated that there was a late delivery of a consignment and that no such facts are stated in the plaint to support the faute lourd or faute caractérisée, and that no cause of action was present in that case. The definitions of faute lourd are given further down at the page.
Well, in this case, the appellant is not asking us to say, look at the alleged facts here. It can't be faute lourd.
Yes, my lord,
That's for the future if his appeal is dismissed.
Yes, my lord, I do totally agree. But all the other cases as well, my lord, the case of Air Austral was based on tort only, a simple faute. No faute lourd was averred. So the judge came to the right conclusion by saying that if there is a simple faute and there is a contract, then one cannot proceed on tort. In the case of Raghunandan as well, Mauritius, which is at tab 20, since there was no averment of faute lourd, the case was dismissed. My submission here is that in all those cases where the learned judges did not entertain the request of a claimant to proceed on tort was due to the fact that there was a simple averment of simple faute, contrarily to here, where we are saying there is a faute lourd. The learned judge might eventually find that there was no faute lourd, but the respondent should at least be allowed to proceed on the merits, to adduce evidence, to try and demonstrate that there was a faute lourd. In my submission, it would therefore be wrong to rely on all those judgments to say that there is non-option in Mauritius. This is not true at all. All these cases do not demonstrate that the principle of non-option is present in Mauritius. All these cases simply state the law, which basically is when you have a contract, you cannot proceed on tort unless, and that's where the exceptions come. If I may refer your lordships to tab 22, MS page 642.
Happy world.
In the case of Siu Kwan Khan, a 2008 case, my lords. In this The pages all seem to be numbered differently.
642 is the electronic page for the beginning of this case.
On the last page, my lords, this is 645. At the bottom, well, before the last page, at the bottom of the page, we are aware that in France, the Cour de Cassation, Chambre Sociale, has in its arrêt number 027 du 10 juillet 2002, added a fourth condition to the validity of a restrictive covenant, namely that it must also compose l'obligation pour l'employeur de verser aux salariés une contrepartie financière. In the absence of full arguments from learned counsel for the appellant, we are not in a position to state that such a condition should be imported wholesale in our law. Of course, this is not a case which relates to footload or to contracts, my lords.
But that's a point on the validity of a restrictive covenant as between employer and employee. Is that right?
Yes, my lord.
Okay.
The purpose of putting
I
this...
think you're citing it to say that the Mauritian courts don't automatically import French developments in French law into Mauritius.
It will actually be my submission in a gist, but those bundles are extremely thick bundles. A lot of authorities, a lot of doctrines have been inserted in that bundle in order to show your lordships that there are different schools of thought. True it is that non-cumul is almost a rule in France and in Mauritius. Option has generally, it seems, been preferred in France. However, as the article by Boris Stark demonstrates, and as other cases will demonstrate, there have been cases where even in France, this rule of non-option has been departed from. There is no doctrinal binding precedent in France, so one Cour de Cassation can make a decision and another Court of Cassation can decide otherwise. There is a case at page 66, tab 66 of the additional bundle, MS page 945. On the next page, paragraph 2, I have tried to translate, my lords, but of course my friend for the appellant will correct me if my translation is wrong. But what this paragraph reads is as follows: "But the breach committed by a party to the contract in the execution of the contract itself triggers his quasi-tortious liability when it is committed in bad faith, or even when it solely amounts to gross negligence, which stems from the deliberate refusal to execute an express contractual duty." And then the last paragraph, which reads "mais attendu que," if I may translate, but whereas in answer to the conclusions already dropped, the judgment holds that the company Gilem Informatique, which has executed the contract CCBP for more than a year and has provided a second contract to MX, has not committed any gross negligence or manœuvre delusive. It further holds that the bad faith from the company Gilem Informatique is not sufficiently constituted of the facts to grant damages separate of contractual damages to which it was condemned. Although this case was obviously the claimants were not successful, what this case tends to show, my lord, is that even in France, this situation has been considered by the Cour de Cassation.
Well, your argument is that if the appellant was right, there was no occasion for the French court to address the question of whether faute lourde had been established, because if the appellant's argument is right, that's irrelevant.
Well, on the facts of this case, yes, the evidence fell short.
Yes, the evidence fell short, but the very fact that they considered it shows that in certain circumstances
they would consider.
It would, yeah.
And with regards to all the other French cases referred to by my friend at tab 68 and in all the list of cases, we agree with these cases as well, because these cases state that these cases do not talk about faute lourde. They state that if there was a faute external to the contract, then one can proceed on tort, which he is saying is not our case here. We do not find anything wrong with these cases, and we are not in disagreement with those cases. All we are saying is that we are standing on a different leg here. Rule 18 of our Supreme Court rules which is at tab 2. The other side of the page. MS page 442.
Thank you.
While it might not be totally, MS page 442, my lord.
And the other numbering?
Tab 2, page 14.
14.
Yes, just it's
14.
in the same tab. It's just on the other side.
Thank you.
While these rules might not be totally relevant, they have been referred to in the cases, and it's Rule 18, joint of actions, subject to paragraph 2, different causes of action of whatever nature by and against the same parties and in the same rights may be joined in the same suit. So our civil procedure is not exactly similar to the one in France, my lord. We do have our own set of rules, and reference to this rule of the Supreme Court is simply to stress on the fact that we do have our own separate rules, and that our judges, having decided to proceed on a certain path with regards to theory of fault law and whether you can actually ground your case on tort, bore in mind the whole structure of the whole Mauritian environment, if I may say so, in deciding to do so. Reference was also made by my friend and by ourselves, and in many judgments, to Article 16 of the Nouveau Code de Procédure Civile, whereby requests were made to the Supreme Court that if a case was wrongly entered on the basis of tort, but the court might send it back on a contractual claim. Unfortunately, and I do agree with my friend for the appellant, this does not hold good in Mauritius. Our judges would not be able to do so, so that a lot of injustice would result if a case was to be dismissed or non-suited simply on the basis that it was entered on tort rather than contract. It is important, in my humble submission, to bear in mind that our rules, our civil procedure rules are different, that some rules do not apply in Mauritius, and that at the end of the day, the courts are here to do justice, and that in the absence of all those rules, one should be more lenient and flexible in the interpretation of those rules. May I also remind the board that the concept of cumul, non-option is not in the law. It is a concept that has been developed in case law. Your Lordships would have probably seen from the bundle as well, an article has been put in by my friend, Mr. Tony Weir, on complex liabilities. While I do not propose to take your Lordships through that whole article, it is extremely clear from the article that some countries allow cumul, some countries do not allow cumul. France generally, cumul and option. France generally is not in favor of cumul and option, but exceptions have happened, and the article of Mr. Weir makes it clear that there is no proper choice between option or non-option. And therefore, it will be my humble submission that if our Mauritian courts have chosen to allow the litigant to proceed on the basis of having an option, then there is no reason to stop it from doing so. two brief submissions just to finish, my lord.
Well, you're doing very well as far as time is concerned.
Just on the special regimes, I do not propose to go through the list of special regimes again, because they are in the bundle, they have been referred to in our written case, but this only tends to add to my submission that we have our local Mauritian context, which can be different from the French context, where additional protection has been given to some litigants under specific laws. And, my lord, finally, with regards to the Code de commerce, the case of l'inattendu is a case where the Code of commerce did apply as well. The Code de commerce applies in this case. It is a contract of transport, but like in any other contract, the reasoning in l'inattendu, in my humble submission, would apply if, by his behavior, the debtor has behaved in a way so as to enable the plaintiff to come and ask that an action in tort, to ask for damages based on tort, because the debtor should not be able to avail himself of all the protection that he would have under the contract. Then, even though if it's under the Code de commerce or not, this should be granted to the claimant. The claimant should be allowed to proceed on tort rather than be debarred from doing so.
I think the point that was being made against you was that the Code de commerce has got some really quite complex rules for, in this case, carriage by sea. Yes. And what we were being asked to say was that it, it would be remarkable if the Commission of Faute Lourde removed all of them. But your contention is it's not remarkable at all. It does remove all of them, but that's fair enough. Is that it?
Yes, my lord.
I see.
But also, an article has been put in the bundle by my friend himself at tab 59, which is a chapter on the transport de marchandises, MS page 875. At paragraph 102.
Paragraph 102.
102.
102.
Well, that's not 875, I'm afraid, but never mind. It's 880.
880, my lord. Paragraph 102, the first line reads, secondly, there has been in countries where the cumul was accepted, the possibility for the, it's in French, I'm trying to translate at the same time, sorry, for the carrier to enter an action in tort. So there are countries where cumul and option are, even in the UK, you can have an action in tort, you can have an action in contract. So there are countries where this state of affairs prevails.
Yes.
And my reading of the Hague-Visby, of moving on from the Hague rules to the Hague-Visby rules, from a reading of these pages as well, and from the travaux préparatoires, was to, first of all, the Hague-Visby rules clearly allows a litigant to proceed on tort. In any case, in this present matter, the case of the respondent is that it should be allowed to proceed on tort because, as an exception.
Yes.
Because.
Yes, we understand what your case is, yes.
I think, unless I can enlighten the board with any other matters.
I think not. Thank you very much indeed. Mr. Arney, how long will you need for a reply?
The 30 minutes I was given would be necessary.
Well, we will adjourn then. We will look forward to hearing from you at 2 o'clock.